Picture this with absolute clarity. Your world has just shattered, not metaphorically, but physically, viscerally, in a way that rearranges your understanding of reality itself. One moment you were going about your day, maybe pumping gas, closing up your shop, or walking to your car after dinner. The next moment, survival wasn't an abstract concept, but the only directive your nervous system recognized. You've just experienced the worst moment of your life, and you survived because you had no choice. You used force to defend yourself. Maybe it was a firearm. Maybe it was a knife. Maybe it was your own two hands. The method matters less than the reality. You crossed the bridge from peaceful citizen to someone who has taken violent action to preserve their own life. Your body is screaming with the aftermath. Your heart isn't just pounding. It feels like it's trying to escape the cage of your ribs, each beat echoing in your ears like a drum signaling danger. Your hands won't stop shaking. Your vision tunnels. Time seems to move both too fast and in slow motion simultaneously. The immediate threat is over. The attacker is no longer advancing. But as you stand there in the eerie silence that follows violence, you need to understand something critical. You're safe, but you are not free. Because at this exact moment, a stopwatch has started. Not one you can see, but a legal and procedural countdown that will determine whether you're treated as a victim or a suspect, whether you go home to your family or to a jail cell. This stopwatch measures what I call the race to 911. Marc Lopez. In my years of defending people who've used force to protect themselves, I've seen one pattern repeat itself with heartbreaking consistency. Good people who survived a violent attack only to be destroyed by the legal system because they didn't understand the rules of this critical race. What follows is not just legal advice. It's a survival manual for the aftermath. A detailed, comprehensive guide through the approximately 5,000 most important words you'll ever need to understand about protecting yourself after you've had to protect yourself. Chapter 1. The Psychology of Aftermath. Understanding your broken brain. Before we discuss what to do, we need to understand what's happening to you in these moments. The neurochemical cascade. When you face a lethal threat, your body undergoes changes more dramatic than any drug could produce. Within seconds, adrenaline floods your system, increasing heart rate, blood pressure, and energy supplies. Cortisol releases, heightening memory formation and preparing your body for trauma. Endorphins pump through you, creating a natural analgesic effect. Vasopressin increases, sharpening focus on survival. This chemical cocktail has one purpose: keep you alive in the next 30 seconds. It doesn't care about tomorrow's court appearance. It sacrifices higher cognitive functions, memory sequencing, detailed recall, linguistic precision, in favor of gross motor skills and threat identification. Dr. Alexis Artwall, a pioneer in police psychology and author of Deadly Force Encounters, describes this state as condition black, a level of arousal where cognitive functioning deteriorates to the point where you're essentially thinking with your spinal cord. The 4 traumas of self-defense. When clients sit in my office after a defensive incident, they're often dealing with 4 distinct traumas. The physical trauma, the actual attack, the fear, the violence. The moral trauma, the psychological burden of having taken violent action. The legal trauma, the terrifying uncertainty of potential prosecution. The procedural trauma, the dehumanizing experience of being treated as a criminal when you believe you're a victim. Most people prepare, if at all, only for the first. The truly prepared understand that survival doesn't end when the threat stops. It continues through the legal and procedural gauntlet that follows. Chapter 2. The Race to 911. Why first contact determines everything. The first mover advantage in law enforcement. Let's dismantle a dangerous myth. The idea that the truth will come out, or good guys have nothing to hide. Law enforcement operates under tremendous pressure. Pressure to resolve situations quickly, pressure to identify perpetrators, pressure to secure scenes, and protect the public. In this high-stress environment, first impressions aren't just important, they're often determinative. When a 911 call comes in, dispatchers create what's called an initial event narrative. This narrative, this first story, becomes the framework through which every subsequent piece of information is filtered. Research in cognitive psychology shows that once an initial narrative is established, contradictory information is often discounted or reinterpreted to fit the existing framework. The practical reality? Whoever calls 911 first establishes the initial narrative. Whoever gets called on becomes part of someone else's story. The dispatcher's mindset. Put yourself in the dispatcher's chair for a moment. You're handling multiple calls, monitoring radio traffic, coordinating multiple units. A call comes in. There's been a shooting at 123 Main Street. A man just shot someone. What's your immediate mental classification? You have a location, a reported crime, shooting, a perpetrator, a man, a victim, someone. Now, 30 seconds later, another call comes in from the same location. I was just attacked. I need help. What's the dispatcher's likely assumption? That this second caller is either the same person calling back with more information, a witness, the perpetrator trying to create an alternative narrative. The system is literally designed to categorize the first reporter as the complaining witness and everyone else as secondary sources at best. Case study: the tragedy of being second. I represented a man, we'll call him David, who was attacked in his own driveway by a neighbor during a property dispute. The neighbor threw the first punch, David defended himself, and during the struggle, the neighbor's head struck the concrete. David, dazed and bleeding, retreated to his house to call 911. Meanwhile, the neighbor's wife, who had watched the entire altercation, called first. Her version? My husband was just assaulted by our neighbor for no reason. By the time police arrived, the narrative was set. David was the aggressor. He spent the night in jail, faced felony charges, and endured 18 months of legal battles before forensic evidence and eyewitness testimony from people who didn't come forward initially finally cleared him. The cost: his life savings, his reputation in the community, and irreparable damage to his family's sense of security. David survived the attack, but nearly lost everything because he lost the race to 911. Chapter 3. The 911 Script. Precision communication under pressure. Why less is more. The single greatest error people make on 911 calls is believing they need to tell their story. This impulse to explain, to justify, to seek validation is natural but legally dangerous. Remember, the purpose of a 911 call is to get emergency services to your location, not to prove your case. Every additional word beyond what's necessary creates potential inconsistencies, admissions, or statements that can be used against you later. Your brain is chemically compromised. Your memory is fragmented. Your ability to sequence events accurately is impaired. The 3-sentence protocol. Memorize this. Practice it. Make it automatic. Sentence 1. I was attacked at exact location. Sure, you weren't justified. I didn't mean to, or it was an accident. Why? Self-defense is intentional. ACC establishes you as the victim, provides critical location information, uses the passive voice strategically, I was attacked rather than someone attacked me, to avoid premature identification that could be incorrect under stress. Sentence 2. I was in fear for my life. States the legal standard for self-defense. Creates a record of your subjective state of mind. Uses the precise terminology that aligns with self-defense law in virtually every jurisdiction. Sentence 3. Send police and an ambulance. Demonstrates you're taking responsible action. Shows concern for all parties, even an attacker. Reinforces your role as the person summoning help rather than fleeing. The danger words. What never to say. Let's examine specific phrases that transform a defensive shooter into a suspect. Never say, I shot him or I fired my gun. Why? You're admitting to the act before establishing justification. Let the evidence speak to what happened. Your words should speak to why. I think he had a weapon, or I believe he was going to attack me. Why? I think and I believe introduce uncertainty. In court, the prosecution will argue that if you weren't identical shootings are negligent. You just move from justified force to criminal negligence. We were arguing, and then... Why? Introduces potential mutual combat scenarios that complicate self-defense claims. Any speculation about the attacker's motivations, background, or state of mind. Why? You're not a mind reader. Speculation creates inconsistencies when facts emerge. The science of stress-induced memory errors. Understanding why you can't trust your own memory in these moments is critical. Temporal distortion. Stress dramatically alters time perception. What felt like 30 seconds might have been 3, or vice versa. When you say it all happened so fast, you're describing a neurological reality, not using a cliché. Weapon focus. Research shows that when a weapon is present, witnesses, including you, focus on the weapon to the exclusion of other details. You might remember the gun clearly, but be completely wrong about what the attacker was wearing or even their height. Sequencing errors. The brain under threat doesn't record events like a video camera. It captures snapshots out of sequence. You might remember the muzzle flash before remembering the verbal threat that preceded it, even if that's not how it happened. Memory contamination. Every time you recall an event, you potentially alter the memory. The 911 call becomes your first retelling, and any errors become embedded as truth in your memory. Chapter 4. The Arrival. Managing the first contact with police. The 60-second preparation window. You've made the call. Now sirens are approaching. These next seconds are your final preparation window. Secure your firearm. If you're still armed, holster or safely ground the weapon. A firearm in hand, when police arrive, makes you an immediate threat. Hands visible. Empty hands in clear view, preferably above your head or outstretched. Position yourself. If safe to do so, move away from the attacker and any weapons. Mental rehearsal. Repeat your key phrases in your mind. Understanding the officer's perspective. The responding officers know almost nothing except there's been a violent incident. Someone may be armed. Someone may be injured. The scene is unstable and dangerous. Their training emphasizes neutralize threats first. Secure the scene. Preserve evidence. Identify victims and suspects. They're not arriving to hear your story. They're arriving to establish control. Their aggression, their commands, their weapons drawn. This isn't personal. It's procedure. The 5-point presentation. When officers approach, they'll give commands. Follow them explicitly. Once they've secured the scene and the immediate threat is neutralized, you'll have a brief window to establish your status. Use these 5 points in order. Point 1. Identity and status. Officer, my name is your name. I am a victim. I called 911. Point 2. Attacker identification. Point clearly, if possible, and say, that person or describe location attacked me. Point 3. Evidence preservation. His weapon is over there. Point without approaching. I haven't touched anything. Point 4. Witness identification. Those people, point to specific individuals, saw what happened. Point 5. Legal justification. I was in fear for my life. I had to defend myself. This sequence does critical work. It establishes you as the complainant. It directs investigation toward the attacker. It preserves evidence without contaminating it. It identifies evidence and witnesses before they disappear. It states your legal justification in clear terms. The handcuff moment. You may be handcuffed. In fact, you should expect it. This doesn't mean you're under arrest. It means you're being secured while the scene is sorted out. If handcuffed, do not resist. Do not complain. Do not say, why are you cuffing me? I'm the victim. Do say, if asked, I understand you're securing the scene. I was defending myself. Resisting or complaining about handcuffs shifts the officer's perception from cooperative victim to uncooperative subject. Chapter 5. The Interrogation Trap. Why you cannot talk your way out. The myth of the quick explanation. Here's the scenario officers are trained to create. They've secured the scene. The immediate danger has passed. An officer approaches you, his tone softening. Okay, I can see you've been through something. Just walk me through what happened so I can get this sorted out and get you home to your family. Everything about this feels right. He's being reasonable. You want to help. You want to go home. So you start talking. This is the trap. The physiology of post-incident interviewing. Remember your neurochemical state? You're still in it. Studies show elevated cortisol and adrenaline can persist for hours after a traumatic event. Your brain is still prioritizing survival over accuracy. When you attempt to give a detailed statement, you will get sequences wrong. You will estimate times incorrectly. You will forget details that seem obvious later. You will include assumptions as facts. You will contradict yourself without realizing it. Each error becomes a prior inconsistent statement that prosecutors can use to attack your credibility. The helpful officer phenomenon. I've reviewed hundreds of hours of body camera footage. One pattern is unmistakable. Officers often express empathy that sounds like validation. I'd have done the same thing. Anyone would be scared in that situation. I get it. You had no choice. These statements feel like reassurance. They're not. They're conversation facilitators designed to lower your guard and encourage talking. Never forget, the officer's job is to gather evidence. Anything you say is evidence. Your perception of him as on your side is irrelevant to how your words will be used later. The magic words. At some point, an officer will ask for your statement. This is your critical moment. You must say, "Officer, I want to cooperate fully, but I'm too shaken up right now to give a clear statement. I will not answer any questions without my attorney present." Then you stop talking. Let's break down why this formulation works. "I want to cooperate fully" shows you're not hostile or hiding. "I'm too shaken up right now" states a fact you are and provides justification. To give a clear statement acknowledges that accuracy matters. "Without my attorney present" invokes a constitutional right in a non-confrontational way. The pressure to talk. After you invoke your right to counsel, you may experience pressure. If you have nothing to hide, this will go faster if you just tell us. The prosecutor will look more favorably. You're making yourself look guilty. These are standard interrogation techniques. Your response should be polite but firm repetition. "I need my attorney before I answer questions." Chapter 6. The Legal Architecture of Self-Defense. Understanding what you're protecting. To understand why silence is golden, you need to understand what prosecutors need to defeat a self-defense claim. Self-defense isn't a get-out-of-jail-free card. It's an affirmative defense that admits the action but claims justification. The burden varies by state. Sometimes the defendant must prove self-defense. Sometimes the prosecution must disprove it. But the elements are generally consistent. Imminent threat of death or serious bodily harm. Reasonable belief that force was necessary. Proportional response. No reasonable retreat in stand your ground states. Not the initial aggressor, unless you clearly withdrew. Every word you say can potentially undermine one of these elements. The prosecutor's playbook. When I was a prosecutor, here's what I look for in self-defense cases. Inconsistent statements. Different versions suggest fabrication. Speculative language. I thought, I believed, it seemed like. Embellishment. Adding details that aren't necessary. Minimization. Downplaying your own role. Characterization. Calling the attacker names or making assumptions. A single 911 call can provide all of these. I've watched jurors turn against defendants because of what they said on that call, not what they did during the incident. The timeline of building your defense. Your legal defense begins in these first moments, but it shouldn't be articulated until much later. The home invasion. Castle doctrine laws provide additional protection, but the procedural rules remain. 911 call. Someone broke into my home at address and attacked me. I was in fear for my life. Send police and ambulance. Key addition. Broke into my home establishes castle doctrine context immediately. Chapter 8. The psychological aftermath. What comes next? Expecting the unexpected. Surviving the legal immediate aftermath is only the beginning. The psychological journey often includes the crash. 24 to 48 hours after the incident, the adrenaline subsides and the reality sets in. This is normal but can be misinterpreted as guilt by investigators. The second guessing. Could I have done something differently? This is universal among responsible people who use force. The isolation. Friends and family may treat you differently. Some will avoid you. Others will leonize you. Neither is helpful. The legal anxiety, the uncertainty of investigation and potential charges creates chronic stress. Building your support system. Before you ever need it, identify a criminal defense attorney experienced in self-defense cases. Have a therapist familiar with trauma ready. Know which friends/family can provide practical, not just emotional support. Have financial resources accessible. Legal defense is expensive. The media problem. In high-profile cases, media may become involved. Your only statement, through your attorney. This was a tragic situation where my client had to defend himself/herself. We are cooperating with the investigation and have no further comment. Do not post on social media. Do not talk to reporters. Do not let family members talk to reporters. Chapter 9. Training and Preparation. Making it automatic. The reality of stress performance. Under extreme stress, you don't rise to the occasion. You fall to your level of training. What's automatic is what you'll do. Drills for the aftermath. The 9/11 drill. Practice the 3 sentences monthly. Have a family member play dispatcher. The arrival drill. Practice securing weapon, hands visible, verbal commands. The invocation drill. Practice saying the magic words calmly under simulated stress. The family drill. Ensure family members know not to speak to police on your behalf. Creating your emergency packet. Keep in a secure but accessible location. Attorney contact information. Emergency contact list. Medical information. Firearm serial numbers and documentation. Insurance information. Legal updates and continuing education. Self-defense law evolves. Castle doctrines expand or contract. Court decisions change interpretations. Make it a habit to review your state's self-defense laws annually. Attend legal updates from reputable instructors. Subscribe to legal defense networks or services. Chapter 10. When it goes wrong, damage control. Recognizing the turning point. Sometimes, despite best efforts, things go badly. You said too much on a 911 call. You gave a statement without an attorney. Evidence is ambiguous or against you. The prosecutor is politically motivated. The attorney's first tasks. When I get a call after an incident, my immediate priorities are client preservation. Stop any further statements, posts, or communications. Evidence preservation. Secure scene access, video, witnesses before disappearance. Narrative control. Craft the initial public and legal narrative. Client care. Address immediate psychological and practical needs. The long game. Self-defense cases can take years. The process is the punishment even if you ultimately prevail. Preparation includes financial planning for legal fees. Emploiement, protection, discussion. Family preparedness for extended stress. Mental health maintenance throughout. Conclusion. The balance of rights and responsibilities. The right to self-defense is fundamental, but it exists within a system that demands accountability. Navigating that system successfully requires understanding that your actions continue long after the trigger is pulled or the blow is struck. The stopwatch starts the moment the threat ends. Your performance in the next minutes, measured, disciplined, legally informed, determines whether you face a prosecutor as a victim or a defendant. Remember the framework. Call first. Establish the narrative. Speak precisely. 3 sentences, no more. Secure and surrender. Make the scene safe for police arrival. Identify and point. Victim, attacker, evidence, witnesses, justification. Invoke and silence. Attorney, then stop talking. This isn't about beating the system. It's about understanding how the system works so that when you've done nothing wrong, the system reaches the right conclusion. The goal isn't to get away with something. It's to ensure that when you've just survived the worst moment of your life, you don't lose your freedom in the aftermath. If you've read this far, you understand that self-defense isn't just about the moment of conflict. It's about everything that follows. Your preparation today determines your freedom tomorrow. I read every comment on my videos and respond to as many as I can. Share your thoughts, questions, or experiences below. 2. But more importantly, prepare, Practice and understand that your words matter as much as your actions. Stay safe, stay prepared, and always remember, in the critical moments after survival, sometimes the most powerful thing you can do is choose silence.